Welcome back to Sunday Live. We're already engaging in conversation here. It's great to have legal analysts with us. Charles Kanjama, thank you, Charles, for making time.
Pleasure.
And Bobby Mkangi. We've been watching the whole relationship between the AU, the African Union, and the ICC, and this extraordinary summit that was held this weekend. They have resolved and feel strongly that no sitting head of state should appear before this international court, and have asked President Kenyatta not to present himself there. We know William Ruto has already headed back, but also they say the court unfairly targets Africa. Let's start with looking at this from a local perspective. What happens if indeed Uhuru Kenyatta was to say, I am heeding what I've been advised by this extraordinary summit, and I shall not present myself to the ICC? What happens then? Charles, let me start with you.
Julie, I think the first thing that we have to say is that there are a number of processes that are already going on that may result in Uhuru not having to go to The Hague before 12th of November. One of them is the application that was filed by his legal team trying to have the case permanently stopped on the ground of abuse of court process. One, of course, is the fresh request for deferral of the case by 1 year that the African Union is going to make. I think there's also a request for referral that is being made to the ICC for the cases to come to Kenya. If they come to Kenya, of course, they will stall. We know that. And there's also the procedural applications to have the case proceed without the president having to be there physically present, and also to have the case proceed with him if he has to be present, then not being at The Hague, but proceeding through video conferencing. So, and then there's also the request to delay the case for a few months until the Court of Appeal decision or the appeals chamber decides on the question of whether the accused has to be present throughout. If any of these proceedings succeeds, then Uhuru may find that he doesn't have to be at The Hague and the case continues with his legal team representing him. But assuming none of those proceedings succeeds, 12th of November comes and Uhuru fails to go to The Hague, then naturally the ICC prosecutor would have to make an application to the court for a warrant of arrest to be issued, which happens in any criminal court when the accused is not present. If that warrant of arrest is issued, it is distributed to all the member states. They are told, if this individual at any time comes to your member state, comes to your country, your territory, your obligations under the statute is to arrest them. So that would mean that the ability of the president to travel would be restricted, probably to the African states that are supporting his decision not to go to the ICC, and that will be ready to ignore the request by the ICC. Probably also some countries like China or Russia may be ready to ignore the summon. So it is a fraught situation.
But huge implications, yes, if indeed you know, none of these attempts to defer or to seek not to have him present in court do not succeed. If they don't succeed, huge implications if he doesn't turn up. Let me reframe the question as I come to you, Bobby, now. What are the implications of having a sitting president in an international court for days on end, weeks on end? And we know, you know, there was a whole, during the campaign saga, there was a whole, this is a personal issue. But what are the real implications of this situation?
I mean, they present huge challenges in the president executing his or her mandate, depending on the country. And in our case, it's a real issue. We might have the sitting head of state being away, you know, through these proceedings, and it presents a huge challenge. There's been the question of whether there's a vacuum of power, of which to me that is not really the case, but the implications on how the country is administrated, how services are delivered to wananchi. We just had the recent Westgate issue, and when you try and picture that, you juxtapose it with such a situation, then you can see how this is a grave issue. But also there's the issue of the optics, the visuals, how when people look at a sitting head of state, for instance, having to bow, having to call another personality, president, having to be to seek permission, to speak, to stand up, to walk away. I think there are huge implications as to the authority of that head of state globally, but also within the countries or the country from which he or she comes from.
Our own country in this case,
yes.
Obviously. Now let's take a more global perspective of this now. And Archbishop Desmond Tutu has spoken on this issue. He is very much in support of Africa remaining, the African Union remaining and supporting the ICC, but he also has complained bitterly about the fact that he does believe Tony Blair and George Bush, former US President George Bush, former UK Prime Minister Tony Blair, should be hauled before the ICC, is the exact words he used, for what he called an immoral war that was based on a lie. And this was the war on Iraq. He gave numbers. He said deaths of 110,000 people. This was as of last year. 4,500 American soldiers, 32,000 soldiers injured, but many others, Iraqis, innocent civilians dead. And it raises the whole question of the consistency and the fairness of the application of this international, or the use of this international court. What are your thoughts on that?
Julie, the first thing to be said is that there have been many over-the-top statements that have been made both by the supporters of the ICC and the critics of the ICC. Desmond Tutu, for example, is a very respected figure, and yet he says that withdrawing from the ICC is a license to kill and maim your own people. I think that is unfortunate. We have also the critics of the ICC who've made very strong statements against the ICC, saying that this court is just an instrument of oppression of Africans. And yet we know that when the court was set up, it was set up with very good motives. So on both sides, there have been too much heat, not as much light. But having said that, there have been those people who have tried to engage in sober debate. And recently, in fact, just 1 or 2 days ago, I was going through a debate that took place in the British House of Commons this week. And they were also discussing the ICC issue. And they were recognizing precisely what you're saying, that when the ICC was set up, it had this aspiration for international justice, truly global, truly without any preferences, without focusing on some people and not others, without selectivity. My very strong view is that selectivity is a real enemy of the rule of law or the ability to get justice. And what has unfortunately happened, in fact, is that the ICC has tended to focus on Africa. Of course, they have their arguments that it is the African countries that have referred some of these cases, and yet they have also got other situations that they have been asked to investigate from other continents. What you mentioned about the war in Iraq, people have gone to the ICC and said, please investigate this, please try to take jurisdiction over this issue. Partly it's for structural reasons that they've been unable to do so. But the bottom line is that the ICC seems to be focused on Africa. And they keep saying that, no, we are not focused on Africa. In fact, our prosecutor is an African countries are great supporters. But these repeated statements are not persuading the African states.
Right, let me come to your thoughts on this, Bobby, and also the standard of the case that we're seeing. And we'll come to that in a minute.
Yes.
Your thoughts on the application of justice by the ICC so far?
I think we have to look at one thing which Charles mentioned, and it's the basis of making this accusation that it leans more towards African countries. And there's a point that we can never forget about how African countries, the 34 African countries, became member parties of this court. It was voluntarily, or these countries voluntarily joined this court for those aspirations that were there and are still there, I want to believe. And secondly also, of the 8 situations that have come on the table of the ICC, 5 of them have been referred by governments from those member states. Of interest, I've been wondering is, for instance, you even look at a country like Uganda, that is one of the biggest critics today of the ICC, but I've not seen any action of Uganda trying to withdraw, for instance, the Joseph Kony and the others issue. So we have to look at it in that perspective of are these allegations, do they come
Have
from
merit?
good
Do they have merit?
and good grounding, so that we can clearly state that ICC proactively and deliberately seeks out African countries. Be that as it may, we also do agree that there is an inordinate number of all these cases come from Africa, but we have to go back and look at the context of and the time when ICC came into being and where Africa was and the conflicts in Africa. But I think what has come out, and I believe part of what was discussed at the AU and offered as a way forward, and especially from the Francophone countries, is that truly there are issues of operation that are problematic with the ICC, probably ideological, and again those are visited by the fact that the implementation of international law right now has a huge problem, where it is seen that might is actually right, where the big powers, the superpowers, it's very hard to implement or enforce international justice against these powers as compared to the smaller powers. So
there is an element
ICC
of the geopolitical
issue right now actually presents that and hits it on the head. And I think that's one of the things that the international community, the African Union having presented the issue, placed it on the table, I think it's one thing that needs to be discussed to see how even these bigger powers can become equal under the line of international law.
Right. Still looking at the ICC and the quality of the case that the whole country and the world, if they are interested, is certainly watching. In Kenya, we had the Supreme Court recently looking at the election petition, and we watched a standard of legal presentation, of legal argument that was absolutely astounding. Our own Kenyan minds there. And somehow, the same audience is now watching the ICC process and seems to be asking questions about the process and the standards of evidence and various other things, including some technicalities that have arisen. What are your thoughts on the standard, the merits and demerits of what we're seeing before us right now?
Julie, my feeling is this, that when we talk of the ICC, we tend to view the court with the judges there as the essence of the ICC, and yet the ICC is composed of about 4 elements: the presidency, the court, the prosecutor, and the registry. And I think some of the criticism that is being made about the quality of justice at the ICC is actually criticism that can be focused at the office of the prosecutor. In Kenya, for example, under our new constitution, we've separated the role of investigation and prosecution of offenses. And in fact, this is the modern standard. But you notice at the ICC, it is the prosecutor who does the investigations. So there could be a conflict of interest. It could be in too much of a rush to take a case to trial, even when he has not done full investigations. And indeed, that has been the consistent criticism of the judges of the ICC against the office of the prosecutor. In the Lubanga case, they criticized him. In the Matthew Chui case, they criticized him. In the Kenyan case, he has been criticized already, and now it is Fatou Bensouda. Of course, it's a she. But Ocampo was criticized repeatedly. What is happening now is that Fatou Bensouda seems totally persuaded that these cases must go all the way because she feels a pressure to do so. Ordinarily, a prosecutor should feel free that if he doesn't have the evidence to take the case all the way, to withdraw the case. So these are some of the challenges that I believe they are structural, that are affecting the quality of the evidence that is coming out.
Let me ask this, Bobby. Considering the evidence that's being presented right now, obviously this is the start. There's much more to come. So we can only comment on what we've seen so far. But what an indictment it would be on the ICC if it continued this way, and these people were found innocent. What would the implications on the institution be if that was the case?
Definitely, and maybe just starting off from what you asked, we'll be able to eventually take a good stock of the standard of evidence upon conclusion of these cases. As you said, it's still early in the day for the 3 remaining for Kenya, but we know of the 6 indictees, 3 were eventually dropped, so we don't know how these others will go. And I think at the end of the day, once the cases are concluded, that's when we'll be able to determine the standard of evidence that was presented before the court. But I think, as Charles has pointed out, this issue has clearly come out in the past, but still with that criticism, for instance, with the Lubanga case, there was a conviction, meaning, and one of the standards that the statute presents and must be met is proof beyond reasonable doubt in all these cases. So we have to wait to see whether the prosecutor will produce evidence that will meet this standard. So far, probably from what we are watching, what we are hearing, we might feel or deem it to be not of a particular standard. But the case is building up. I think as we go on, we'll be able to tell whether that standard that the statute presents has been met by the prosecution or not.
Let's bring it back to the local scene now. And you always get a sense of Kenyans have washed their hands of this issue and are willing to blame 3 people for everything that happened in 2008. So there's a sense of there's no justice for victims if we do not have these 3 at the ICC. A lot happened, I think, in 2000 and 2008, including the fact that, and this is my pet subject, people are still living next to people who raped them. They're still, living next to people who burnt their homes, or they were moved to other parts of the country, still have not been able to recover from what they've gone through. So local mechanisms of justice at the grassroots level, gentlemen, how do we effect these?
You see, what happened is unfortunate, that in the immediate aftermath of the post-election violence, there were so many criminal offenses that had been committed. It is not only the case in Kenya, but is in any country where you have mass criminal activity being committed, that the level of evidence that tends to be collected is low for each case. The criminal justice system tends to be overwhelmed. In the Kenyan case, maybe there was also a deliberate failure to collect evidence. Eventually, when the Office of the Director of Public Prosecution set up a team to look at all the complaints that had been made in regard to post-election violence, they went through over 1,000 cases, 1,000 files. And in each of the files, after scrutiny, they said, look, not enough evidence was collected. And unfortunately, the fact is that with the passage of time, the quality of evidence gets eroded. So that it's not easy to collect evidence today that you didn't collect 1 month ago or 2 years ago. And that is why, unfortunately, we've ended up focusing on this case. The other reason is that the Waki Commission of Inquiry, which was requested to make recommendations on justice for victims, ended up focusing on its recommendations on the most serious perpetrators. In fact, when they came up with this binary option of special tribunal or the ICC, they were focusing on those who are most responsible. So somehow they also helped us to forget about the thousands who committed the atrocities, financed the ordinary perpetrators who in fact have ended up going scot-free, which is a shame.
But even at political level, the principles at the time were not on the list, and I think, there'll be questions about Waki and how that list came up and the evidence for that. But as we discuss this, we keep talking about African solutions. So just borrowing from even our neighbors, is it not possible to start reconciliation or attempts to just say, let's deal with the fact that there were victims and perpetrators that's still living in a certain amount of pain?
And I think that's what we've seen in the past 6 or so years, since 2007, early 2008. And for me, it begs the question whether we've had the will to actually deal with this situation, whether it's the serious or the most serious perpetrators and the small, medium level perpetrators, whether the will has always has ever been and had ever been there. And when you look at, as you say, a country like Rwanda, the way they dealt with the genocide there, there was a tribunal that tried those who were suspected to be the main perpetrators to hold the most responsibility. But they did set up local institutions, the Gashasha courts, that handled the neighbors, the people who wanted to come up and own up, and also help to reconcile the community and help them move forward. And that is what has been lacking here. We haven't come up with those mechanisms, the extrajudicial mechanisms that will help us heal the wounds, will help neighbors to move back together. And even when they have been pronounced, to me, coincidentally, they have always been when people are about to go to The Hague. That's when you hear of certain situations being created, elders from communities meeting. And I always wonder why this has not been an ongoing process. So I think we have failed in that aspect locally in trying to find solutions, both judicial and extrajudicial, to deal with the perpetrators, but also help people heal and come together. And I think that's why the international community has been seeing us as being looking away from what happened in 2007.
Rather lethargic about this.
Exactly, other than dealing with it.
Let's now, as we wind up, take a look at the situation facing President Uhuru Kenyatta and the situation facing the Republic of Kenya. If you were a legal advisor to both, what advice would you give? Charles?
I think for me it is clear, Julie, that if possible, Uhuru Kenyatta should clear his name at the ICC. I think it is not an absolute piece of advice saying you must go regardless of what they do. It depends on the procedural steps, what I'm calling the procedural decisions of the ICC. If you find, and I'm assuming I'm addressing Uhuru Kenyatta, if he finds that to attend the ICC is not compatible anymore with discharging his constitutional duties and the electoral mandate that he got on 4th of March 2013, then he would be forced to default, because it would now be an issue of choosing between two bad options. One option of failing to discharge your mandate in Kenya, and one option where Kenya becomes isolated. Both of them are not great choices, but you have to take the choice that you think is the better option. So I would probably advise him that, first of all, to keep on cooperating with the court to see whether the court would make decisions that are reasonable and sensitive to his views on the matter. And before I finish what I'm saying, there have been one or two judges at the ICC who, in my view, are misinterpreting Article 27 of the Rome Statute, which talks about the equal treatment of everyone. Everyone is subject to the statute, including heads of state and government. And the argument that some judges are using, and the Office of the Prosecutor is using, is that this provision justifies treating a head of state as you would treat any other person who is before the ICC. But when you look at Article 27, it is really talking about jurisdiction of the court being global, regardless of whether you are head of government or not. In all legal cases, and I'm a practicing lawyer, I go to court. The court always takes into account the situation or condition of the person who's before you. If an accused comes and says, look, I lost my brother or my wife 2 days ago, I'm not ready to proceed, you'll adjourn the case.
It
will
not
say equality,
right.
We can't change anything, you have to treat you equally. That is the problem, in my view, that if that interpretation of Article 27 prevails, then it would force Uhuru Kenyatta to default on the duty to attend.
Thank you. So what you're saying is, it doesn't say do not be humane to the people
or
you are
do not consider the fact that somebody has constitutional duties. And that is also what the African Union has said to the ICC.
Thank you for that. Bobby, you have the final word.
I think hot on the heels of the constitutional duty, the President and Deputy President on the 9th of April this year took oath to preserve and protect the Constitution of Kenya. And part of that Constitution does obligate us as a country to implement, enforce the international obligations that we've voluntarily gotten into. And one of them is the ICC Treaty, of which we are a member state. Secondly, when you look at the Constitution itself, Article 143.4, which immunes the president against civil and criminal proceedings does waive that immunity when it comes to international crimes of which Kenya is a member to the treaty, and the president is supposed to attend or be prosecuted under that treaty, of which the present case is the ICC and the Rome Statute. So in the president choosing to default, then he will be going against the very constitution he did swear to protect and preserve on the 9th of April. And the last thing I would tell the president is that he did not take mandate to represent the AU, but the people of the Republic of Kenya through the constitution that gives them sovereignty, sovereign power beholden unto them. And I think the best way to move, and he has said this even before he was voted in as president, that he was going to cooperate with the ICC, and I would ask him to continue in that way unless decided otherwise through the same court.
Thank you, gentlemen, for shedding some light. There's a lot of heat on this issue, and there's always a need to shed some legal light on the options. Your thoughts are coming in. Some of them are hot. I'll just read a couple before we take a break. This one is David from Rongo. He says, let the president go and clear his name, like what Deputy President Ruto is doing, and not be misleaded by the AU leaders. Somebody else says, no, the sitting democratic elected president cannot and should never appear for trial before the ICC. It would be repugnant and inconsistent to the rule of our land. Another one here, the AU is misleading Kenya. If President Uhuru knows what's best for Kenya, he should do what's best by going to The Hague to clear his name. Many SMSs coming in, a lot of people very passionate about this. The one hope that we have is we'll take direction from this, start to look at issues such as local systems for justice, rather than let the issue heighten the tension in the country. We'll be back in just a short while with Sunday Live. Stay with us.